my name is Remedios, solicitor at RLegal Solicitors. Today I am going to be talking about the judgment of MM and others handed down on 26th of February 2017 by the Supreme Court, which some of you will be familiar with and, as you may know, has had a significant impact on partner-related visas. What is a partner visa? Who does it apply to? Partner visas apply to fiancés, proposed civil partners, and those seeking to become spouses. It will perhaps be helpful if I set the scene. Prior to 4th of July 2012, an applicant, broadly speaking, needed to show the following in order to be eligible to apply for a partner-related visa. Number one, that the relationship was genuine. Number two, that there was adequate maintenance. And number three, that there was adequate accommodation available. The important point to bear in mind was that there was no set financial requirement for the maintenance element. So there was an element of subjectiveness. If a decision maker made a negative decision, the applicant could appeal to a court and a judge could further investigate. This allowed for different types of decision making or different results. Applicants or appellants, as they were known in the court, would present evidence of their financial support, for example from relatives or from an employer who was willing to make a job offer. The judge would interview the relative or the proposed employer and sift through the evidence, and he would question the uncle or the employer and reach a decision as to whether the evidence and what they were offering was credible, and if so, would potentially allow the case in the appellant's favour. Although the Human Rights Act was in play at that time, it's probably fair to say that it was still in just beyond the embryonic stage, but people could succeed on an Article 8 argument. Broadly speaking, to succeed on Article 8, an applicant needs to show that number one, there is a family life, number two, that there has been an interference with it by the state, number three, that the interference by the state is disproportionate, and number four, carry out a balancing exercise. Then along came the then Home Secretary, one Theresa May, who on the 9th of July introduced new rules into the immigration rules, which are known as Appendix FM. The introduction through Appendix FM was a minimal financial requirement of $18,600 per annum, which the sponsor had to earn. It could also be satisfied by having a substantial amount of savings, and there was an avenue for those who were receiving certain state benefits to be exempt. Now, the stated aim of the Appendix FM was to reduce migrant numbers, and also the government said the rules allowed for compliance with the Human Rights Act, and therefore no further investigation of it, for example, third parties, was necessary. Now, Appendix FM was appealed in the case of MM. For our purposes, round one was the upper tribunal. Judge in this case was unsure how a justification of $18,600 per annum could be imposed, but did not strike down the rule. Round two was at the Court of Appeal, and here the judges found that there was a rationale to have an $18,600 rule, as this had been researched by an independent body known as the Migration Advisory Committee, and the judge here said that there is clearly a rational connection between the figures chosen and the aim of the policy. Round three has been the Supreme Court decision. The decision itself and the headline by the media was that the $18,600 minimum financial requirement was upheld, and therefore this was a victory for the government. But it's not all quite as what it seems. The decision, in my view, is a landmark one. It demonstrates how the Human Rights Act sits alongside domestic rules here, the immigration laws, or indeed, one could argue, above it. In a nutshell, the rules are statements of policy. Number 2, the court said, should be allowed to pursue a stated aim, which is to reduce migrant numbers, and therefore be allowed to impose a minimal financial requirement of £18,600. However, the court said there is a gap in the rules and the policy guidance, which are to be treated as rules. For those who do not meet it, the court found that the rules and the guidance do not address human rights issues adequately, and that there's an appellate authority or court system in place, and that the Human Rights Act is an act of Parliament which has to be considered by decision makers, including judges. The guidance notes now need to address this gap, and this is what the Home Office are currently doing. The current position, therefore, is that we have potentially 2 avenues for applicants. You either meet the requirements of the rules of the 18,600. If you don't, you potentially present a case where you argue that alternatively how you could meet the requirements of the laws through introduction of a third party such as an uncle or an employer. The danger here is at the moment is that if you get refused, which is potentially the case, is that you'd be looking at a wait of around 12 to 18 months for the court case to be heard. Alternatively, one could just simply wait to see what the Home Office do with their guidance notes. The guidance notes may make the path more clear for applicants, but one thing is very clear: if the case goes to a court hearing, the judges will still be the final arbiter on the Human Rights Act, which is a somewhat victory one could argue, for the wider public. I would recommend that if you are in a relationship and are looking to come to the UK, remain in the UK under the partner rules, that you seek the services of a solicitor. Of course, RLegal can assist you in partner-related issues, and one of the team would be happy to discuss your case. You can do so by looking at the caption below. Thank you and goodbye.